Questions, comments, observations? Yes.
I'll go ahead and get it started, and I apologize for my voice. I'll start.
Do you want to identify yourself?
Oh, sorry, I'm Patrick Ruff. I'm Visiting Assistant Professor of Law at Arizona State University. So I'll start with Aaron since it's fresh in our mind. Am I right in thinking your big concern is about line drawing, right? And we're worried about courts saying what is a religious organization and what's not. I don't see, I mean, is your concern that courts specifically are going to be forced to do this line drawing, or the governments generally are? Because the U.S. Code does it a lot. The obvious example would be Title 26, the tax code. If you look at 501c3, the exemption is organized for religious purposes. You also see that in Section 508, which specifically exempts churches from having to basically put in this form to be categorized as a 501c. So is that also problematic under your theory, or are you more just concerned about the courts placing themselves in that role?
I'm more concerned about the courts doing it. I'm particularly concerned about courts doing it as a constitutional matter. Congress can define whatever it wants to be religion for whatever statutory purpose it decides, and the courts can interpret that. The Seeger case that I mentioned is a statutory case. It is about exemptions from the draft. And so I think if you're defining religion or anything else for statutory purposes, that's one thing. When you have courts doing it for constitutional purposes, that's a little more concerning to me.
I'm Nancy Nauer from Temple Law School. I actually teach religion in the law. So I would like to say that that's exactly right, that for exempt organization purposes, you do have the discussion of what's a religious organization and what is a church, but ultimately when the courts define that, they're usually constrained by the Establishment Clause, and they go right into the sincerely held belief. So that in addition to the conscientious objector cases, you have a whole bunch of folks trying to say that they're a church, and as a church everything should be deductible and stuff like that. So you get that there as well, but it immediately goes to a constitutional issue, and that's the long-standing feud between the IRS and the Scientologists. Was a question of whether or not they qualified as a religion. So, but I just wanted to...
I have to say I love to teach the Ballard case.
Yeah, exactly.
We could do a whole class on Ballard.
Oh,
right?
tell them what that...
Oh, well, he knows what Ballard is.
Yeah.
He'll tell you.
Yeah.
The Ballards were the I Am movement, and they
Right.
were just passing the hat through the mails, and they were
Right.
prosecuted,
Right.
for fraud. And the same retreat, just sincerely held belief. But you mentioned a number of cases like that, the sniff test idea. But let me ask the question: is it necessarily a problem if the courts keep deferring the question forever? Right. In other words, you're saying, well, this is coming to a head now. It's coming to some point that needs a resolution. But at least since the Mormon case, Reynolds, they just keep refusing. Right? Is that? Why can't we just keep muddling through? I guess would be the question. Or evading. Why is evasion a better approach to this problem?
Punting.
Punting.
I like evasion. I think decisional sequencing could be one answer here, and if you can address an issue of religious freedom under the speech clause and do it that way, without having to decide the religious question, that would be very helpful, because the speech clause doesn't have the same tensions that the religion clauses do. And it is punting, but we've gotten along so far without it, I think. And I think courts in Europe, for example, where they don't have the establishment problem, do define religion under their equivalent of the Constitution, end up with problems, and you end up with bad cases like JFS, where they said religion means membership is equated with belief, and that's just not the case.
Just to build on that connection between speech and religion here, where does association come in? John and Nazir just did a brand new book arguing that we need to reestablish, arguing for basically the importance of association as a right viewed really independently of the speech issue. And this is very similar to what McConnell argued when he argued the CLS v. Martinez case a couple years ago, where it was basically who can you exclude from a religious group on a publicly funded law school campus. But it seems to me like a lot of these issues that come up with kind of Hosanna Tabor style things raise a lot of association issues as well that haven't really been directly addressed in the church autonomy cases. So if you could something like that possibly be maybe a new direction that these cases could go that could really, could you decide a lot of these cases, I guess is what I'm asking, on an association ground and adequately deal with the issues they bring up?
You mean adequately avoid the religion issues?
Yeah.
It's intriguing. There's a paper recently published that I haven't read yet called The Four Freedoms that tries to tie together the different bases in the First Amendment, because they all do kind of protect very similar things, and I haven't read it yet, but I'll get back to you.
When's the question?
Okay, so I also have a question for Josh on litigation strategy. It seems to me like you're making the argument that the Affordable Care Act cases really established precedents, if I may use the term, in terms of litigation strategy with originalism. And that based on how a lot of self-proclaimed originalists who were involved in this case decided to operate without referring to originalism. Now that's going to be harder to do in the future. So I'm wondering if you could elaborate on that, and how has originalism been used in recent litigation strategy? What is the trajectory? If we plug this in, not just looking at this case in isolation, but what is the trajectory in the use of originalism in litigation? Is this really a big turn? Is this a trend that you see? How does that work?
Well, I think there are a couple answers to your question. On the one hand, a common criticism of Justice Scalia is that he's a faint-hearted originalist. You might have heard this, that he uses originalism when it's convenient for him, and when he doesn't, it's not. And many libertarians are very fond of criticizing Scalia for that. In effect, though, that's what many originalists said in this case. Well, we agree that originalism will probably dictate one result, but we're not going to pursue that because it's not viable. It's not feasible to get votes for that. I don't think that this will necessarily hinder originalism or prevent originalists from making these arguments in the future. What I do think it will do, though, is perhaps undercut some of the normative appeal of originalism. That if we say originalism is this jurisprudence that's meant to kind of have some sort of objective meaning in the Constitution, or in reality, if we see it's being used as a way to kind of achieve certain libertarian results, I think that may be viewed by some cynics as pouncing grounds for originalism, saying, hey, listen, this was the case, you have all these prominent originalists, they could have made this argument, but they didn't. Now, where originalism does have a lot more cachet, I think, is in cases where the jurisprudential slate is clean. For example, in District of Columbia v. Heller, which recognized individual right to keep and bear arms, or McDonald v. Chicago, which incorporated or extended the Second Amendment to the states. Here you were dealing with cases that didn't have a lot of precedents that were well entrenched. They were more or less kind of blank slates. And in that case, when the Supreme Court was willing to write on this blank slate, I think originalism helped. When you have a case like, when you have a line of cases like Wicker v. Filburn or Gonzales v. Rage, these are entrenched. They're not going anywhere. And I think what this case realized is the vitality of originalism in these cases is not very useful. And to the extent that originalism is useful, it's only to prevent further expansions of Wickard and to prevent further expansions of Rage. It's saying, we went this far in the 30s, we shall go no further. And then to the extent that originalism can constrain that, that might be its force. But the notion of restoring the lost constitution, so to speak, I think this case laid bare that that's an end that's probably very difficult to obtain with originalism. And if it can't be obtained, all this historical research can do is kind of change our understanding of how the Constitution was viewed by the founders and what that means to us. But it's a concession, at least implicitly, that the courts will not use that to move forward. And perhaps in the long term, this might do, there were short-term gains and long-term benefits. The short-term benefit was perhaps striking down the Affordable Care Act. But the long-term harm was perhaps weakening the jurisprudence to get there. And there's a tension that I think was not fully explored because this case went so fast, so quickly, there wasn't time to kind of elaborate and think and pontificate about what exactly was going on. It was kind of, we gotta get this law, and we have 2 years to do it before the election. And it was a very concerted, speeded effort to get there. And I don't know what the long-term effects were. I think it's just important now that everything's kind of settling down to ask these kinds of questions and reflect on what this will mean going forward.
So I have a curiosity about the idea of the frivolous argument. If I understand you correctly, you're attributing, I think, a lot of legal change to change in public opinion, at least the ability to whip up public opinion. But at the same time, you're saying, well, people won't accept a frivolous argument, or it's not a frivolous argument if people accept it. But I think you're really talking about two different things. People will accept an argument that jives with their pre-existing view of what should happen. And in that sense, there's a big difference between that and what is a legally frivolous argument. And I guess maybe one question would be, why is it that this got so much? I would have thought that something like the flag burning case was probably a fairly straightforward case, even though there was a lot of opposition to it. If that question makes any sense.
No, I understand your question. Dan Kahan at Yale is doing a lot about cultural cognition, this idea that we accept ideas that import what we already believe in. People who tend to be conservative will like to watch Fox News because it tells them what they like. People who tend to be liberal watch MSNBC because it tells them what they want to hear. And I don't think there's anything unique about that. I meant frivolous in the legal sense. Of course, if you have some rabid Tea Party person, they're going to assume that this law is unconstitutional because President Obama enacted it. I don't think there's any problem there. I'm talking about a broader legal understanding that this argument has merit. And why this argument got legs is because prominent mainstream Republicans got behind it. This wasn't just kind of the periphery of the conservative establishment. This was a mainstream challenge. If you look at the debates in the Senate, when this was being debated, there were only maybe a handful of senators, maybe 4 or 5 senators who actually raised constitutional arguments. If you look at the brief submitted to the Supreme Court for the case, almost every member of Congress submitted a brief. This expanded to almost all things, and when the prominent political establishment gets behind this movement, it gives it legs. Elsewhere, I've been thinking about writing about what does it mean when senators write a brief to the Supreme Court? What kind of weight does that give it? Because now it's having the elected branches weighing in on the issue. And I think that's what gave this thing vitality. From the very outset, there was actually a very important report that Randy Barnett wrote with Todd Graziano and Nathaniel Stewart. It was presented to the Heritage Foundation on December 9th, 2009. And at this session, Senator Orrin Hatch attended. So this wasn't just some kind of academic conference. You now had the former head of this House Senate Judiciary Committee at a conference. And this gives it weight. This gives it importance. This isn't just a bunch of academics sitting in a room pontificating, no offense. But this is, people with power and influence who can make things happen getting behind it. And I think once people realize that this is the president's signature legislation, and if this goes down, the president will have a serious hard time getting reelected, I think there was a lot more strength to kind of take this down. I think that enabled to go, from off the wall to on the wall, or from frivolous to non-frivolous, so to speak. And that is one of the most enduring lessons of how quickly it happened. If we look at other social movements, for example, the NAACP Legal Defense Fund, it took them decades to make changes in constitutional law. If you look at, for example, the gay rights movement, to go from a case like a Bowers v. Hardwick to a Lawrence v. Texas, and now whatever the DOMA case coming up probably in the near future, it took decades. This took 2 years, barely 2 years, to effect a fundamental rethinking in how constitutional law is shaped. Because if you had asked any common law person in 2008, what's the answer to this question, it would have been obvious. Very shortly thereafter, the answer wasn't obvious. And that's a tribute to the strategy and how they were able to kind of make this happen so quickly.
I want to ask you 3 questions myself, but go ahead.
Please.
Hi, I'm Jason Lamb from Temple University. Notwithstanding the trends that you illustrated about, a small group of senators challenging on constitutional grounds and later pretty much everyone getting involved, I would have to say that it's been more than 2 years as far as there's been a slew of dissents and concurrences where the justices have hinted to, okay, Scalia and Thomas, to be exact, I'm willing to go here if this argument comes before me. Or they'll put in, like an extra 2 sentences that just, illustrates, okay, even though we've gone this way, I want to push back on this 50 years of expansion of the power of Congress under the Commerce Clause. And when you look at the legal arguments that were made, especially through the amicus briefs, despite what the litigants did or didn't do, there were tons of very, very strong legal arguments that were grounded in originalism and grounded in, you could take almost any interpretive strategy and find that this law really was not what it needed to be. And you can see the gymnastics that Justice Roberts went through kind of shined a light on that. So I would say that it's been more than 2 years. It's been a 2-year movement as far as this case is concerned, but definitely the thinking involved, and even, the thinking among academics who accepted the precedences, there was a shakiness about Wicker and a shakiness about Raich, about this doesn't feel right. So they needed someone to put some teeth to it, and now you have a place where I think a lot of people are a little bit more comfortable with where the bounds are drawn now. Because even people who believe in strong power under the Commerce Clause thought we were past the line. So I think this is more than just the last 2 years.
That was one of my questions, so I was right. It's a good, I think this sort of mushroom, the way you presented it anyway, it's like it just pops up like a mushroom and it has a 20-year history that could be told. And a related point, Post and Siegel have argued, I think persuasively, that originalism is not really a jurisprudential theory. It's, when Scalia is writing that stuff, he's not writing about jurisprudence. He's got a different audience in mind. And that's the folks who became the Tea Party. It's a popular constitutional framework. It's to communicate politically to the base, right? And if you rethink who his audience might be when you read those dissents that were mentioned, so that, I think that kind of has to be factored in, and it isn't a challenge to you. It's just a way of saying, the timeline here has to be at least 20 years, if not longer.
So let me address both of those questions at once, if I may. You're absolutely correct. Justice Thomas has been writing little 2-sentence dissents for years saying he'd revisit Wickard. In fact, in NFIB, everyone forgets that the easiest opinion to understand was Thomas's. He said, I threw all this crap out the window. But no one joined him. And even though Thomas was suggesting he'd be willing to revisit Wickard, Scalia didn't. He concurred in Raich saying he wouldn't. So while there were some cases, for example, in Lopez and Morrison, where they perhaps put limits on Raich, only Justice Thomas was willing to actually revisit it. The strategy advanced in NFIB was not to get rid of 7-year-old precedents. They made that very clear. They weren't trying to. Now, does Randy Barnett want to overturn Wickard? Probably. But that's not the strategy he advanced in this case. He was very clear about that. So I think the 20-year history, though, was this kind of originalist resurgence, so to speak, of knowing that there are justiciable limits in the Commerce Clause. But that wasn't this. They weren't arguing that because of the original understanding of commerce that this law has to go down. Their argument was purely based on accepting Wickard and accepting Raich, and that, I think, is new. Most constitutional libertarians and conservatives premised their arguments on Wickard and Raich being wrong, and that was the groundswell of support. Here, this is something different. They're saying, we will assume they're correct, and we will assume that the New Deal settlement was what it was, but even there so, it can't go further. I think that's what's unique. They made that conscious decision. Now, attacks on Wickard and Raich certainly set the groundswell, but this was something that was very precise in the way they litigated it. Now, to answer your question, Siegel and Post article, Heller, Dead or Alive, it was a Harvard Law Review Forward in 2008. It was an excellent piece, and I cited it a couple times in my article. I think Siegel and Post, I don't agree with them entirely, but they have many good points. How originalism is in many senses kind of a popular constitutionalist movement that speaks to people's desired to restore some gilded era of the past and have this, this wonderful constitutional liberty that the founders intended us to have. I think that's a powerful argument. I won't discount originalism altogether because I think there is some sort of certainty that can be gathered from history. And if you look at the majority and dissent in Heller, they were both originalist opinions. They both were, just at various strands. So I think it would be a little too narrow-minded to discount the jurisprudence outright. But what I think this case had was they kind of blended this popular constitutionalist notion of what the Constitution means without directly attacking, here's what these provisions mean. These phrases like, the Constitution does not permit mandates, but they didn't actually advance what it was. We all know that Paul Clement argued this case with the Supreme Court. And his argument was based entirely on existing precedents. This wasn't like, for example, McDonald v. Chicago, where the petitioners were asking the Supreme Court to overturn the slaughterhouse cases, or in D.C. v. Heller, where the petitioners were asking them to overturn U.S. v. Miller, a 90-year-old precedent. This was a slightly different case. I think you're absolutely correct that the 20 years of the conservative legal movement set the stage for this, but I think this was of a different shape and kind, and I think it was prodded on by the exigencies of this law that came on quickly and had to die quickly. This wasn't something that could be litigated for a long time. This had to be done right away because of the monumental political outcomes of it. And I think that's somewhat very important.
And so, tagging onto that idea, right, a case that arose quickly, needed to be solved quickly, and I'm going to say something that I usually try to spend months and months getting my students to not say.
Please.
But so the case, of course, that it reminds me of is Bush v. Gore, right? And in this case, I actually do not believe that the ideology, that the trappings, that the ideology, that the justifications, in some sense, I don't believe any of it mattered. I mean, like Bush v. Gore, this to me seems to be a case that at its heart is fundamentally about policy preferences and is to me, that sort of sense of you can dress it up any way you want. But I'm sorry, Justice Roberts, this does not work. To me, the four conservatives, clearly that this is, a 20-year campaign, and that the window dressing, the arguments, the justifications, whether it's originalism, whether, to me, in this, again, to me, this is sort of a lowest common denominator argument, and one that I hate it when my students say, but I actually don't believe that any of that really mattered.
And
so I would love to be convinced.
I'm not going to even try and convince you. My focus is not on whether there are merits or not. My intent is just studying the strategy and studying how they did it and drawing lessons from it. Now, I think your analogy to Bush v. Gore is actually very good. If you look at the 30-something days from when the case began, the legal argument that it would violate the Equal Protection Clause for Florida Supreme Court to order some counties to have recounts and other counties not to was totally novel. That's something that the Bush campaign cooked up really quickly. And it was a really good idea. I mean, it's a legalistic argument that if I would have told that to you on November 3rd, 2000, what are you talking about? Why can't a court order recounts in places where there were some kind of irregularities? But they made a legalistic argument. Why couldn't Congress tax people for not buying health insurance? It's a mandate, that'd be unprecedented. So this idea of creating legalistic arguments in a very short span necessitates making some sacrifices of it not being perhaps as refined as you'd like. But the exigencies of politics sometimes call, and this had to be done. I didn't mention this in my talk, but at the Federal Society Lawyers Convention, November 2009, this is about a couple months before the Senate passed a law. I was actually at the Federal Society Convention, and I'm not exaggerating, but there were a number of prominent conservatives and libertarians walking the hallways, asking people, so what do we do about this law? What kind of strategy do we come up with? Todd Gaziano, who was at the Heritage Foundation, he wrote the key report with Randy. He said, hey, Josh, you want to help me write a report on this law? I'm like, I was actually clerking at the time, so I couldn't. It would not have been appropriate for me to do this. Like, I'm sorry, I can't help. But I sat there and I listened. And then he talked to Randy, and he said to Randy, hey, Randy, what do you think about this law? And Barnett said, well, I haven't given it much thought yet. And then really in the span of like maybe a week or two, they came up with this report which they published. I think it was published on December 9th, and Orrin Hatch came on board with it, and it laid out the case of why this is unconstitutional. And people started joining it little bit by little bit. And just the process by which this happened, and the speed, and how quickly the arguments were refined. I mean, the blogs played such a key role in this entire debate. How you had arguments between Jack Balkin and Randy Barnett and Warren Kerr and Ilya Soman and all these bloggers going back and forth, whereas in the past, academic debates took place over the course of years at colloquia and conferences This happened in the matter of minutes. I mean, there were times when Randy and Orrin would go back 4 times in one day, refining the arguments. If you actually trace how the arguments advance, how the taxing power advanced, how the commerce argument advanced, how the, read the original December 9th report and then compare that to the final brief, and it's a very different beast. In the original report, there were actually some originalist arguments being made about Heller and McDonald and how this is actually McDonald didn't exist yet, but Heller and how this has been a good challenge. My focus is not to say whether this is political or not. I won't persuade you one way or the other. My focus is just to look at how the strategy happened, how this evolved, and perhaps what we could learn about this for future constitutional challenges, because in the midst of it, it was going so fast, no one really had the time to think about what was going on. And sometimes that's not a very good way to do constitutional litigation, but maybe in a Bush v. Gore case where there's going to be a precedent January 17th, there's no question about it, someone will be inaugurated that day. And you know that this case has to go to the Supreme Court before the 2012 election, because that's a really big deal. That's why Florida and Virginia, the suits that were being filed, they did it minutes after the law was signed. They wanted to be first. And this was a rocket right to the Supreme Court.
I want to ask Jared a question.
Yeah, I was going to say I wanted to ask Jared a question. You go right
Go
ahead.
ahead. You go ahead.
No, I was going to say I have more questions for Josh, but I want to get I want to talk about what cereal I eat in the morning. So I want to get Jared in here. And I've been reading stuff lately about greenwashing, that companies will, in their advertising and marketing budget, say that they are all natural, or that they're organic, or that they're sustainable. And apparently there's a whole demographic of consumers out there that will pay extra for that. So I was wondering what you thought, what is going to be the result of these three sort of competing definitions of sustainability? Are they going to produce like a good housekeeping seal of approval that's going to be for consumers, or is it going to be something more?
Yeah, that's a good question. I mean, the primary, so I make the argument that the primary motivation, revolving all of this is self-interest. So the primary market mover here is Walmart, who's probably one of, if not the biggest market movers in this country, if not the world. I mean, it's all about being able to stamp sustainability on their product to move it off the shelf more and more. So I guess your question is that really all they're after, or are they after something more substantive?
Yeah.
Because I think it depends on the perspective. And maybe in their heart of hearts, Walmart executives are really, really concerned about the global health. Maybe that's true. Maybe that's true. Yeah, right. Sure. Maybe that's true. Maybe it's not. I don't really want to touch that one way or the other, to be honest with you. But I think at a fundamental level, from an environmental NGO perspective, and even from an organic production perspective, I think there's a genuine concern about the viability of the continued existence of humanity on this planet, which is a legitimate concern to have. Right. So we can have more conferences in Columbia. From a conventional producer perspective, though, I think it's somewhere in the middle. I think at the end of the day, a farmer has to feed his or her family. Now, I'm taking kind of a nostalgic notion of farmer in that, it's a small family farm, and that's just not the case in a lot of instances anymore. But that still does exist, and it exists to a large degree in this country. So, I think the short answer is it's a blend. It's a blend, it's a mix, and it depends on what perspective you're coming from.
So there really is sort of an interest convergence then between the marketing folks who want to get us to buy sustainability and the fact that if it really is sustainable, it actually is good for us.
Right, and I actually didn't have time in my presentation, but in my paper I argue that point, that there is overlap here between these three, where if the market power of Walmart can be captured into something that's actually substantive, that the NGO world is looking for, and that can be economically viable for the producers, this really is kind of converging to a point where you could really see big movement on something that's really, really important. At least I think it's really, really
Through
important.
Walmart.
Through Walmart.
Yeah.
Yeah.
our crop production in our country is already heavily subsidized, especially corn and wheat. Do you foresee our government stepping in and subsidizing sustainable farmland or organic production to close the gap, the economic gap, so that more people have access to those crops that are it's pretty much accepted that they're better for you nutritionally? So do you see that on the horizon? Is that something that would be fought by the current establishment? Like, where does that stand?
So, let me restate your question to make sure I understand it. Do I foresee the government subsidizing organic production because that is accepted as more nutritious to us as an individual person?
Do you see it happening at all, and why? Why would they do it? It makes sense to me, but I'm not.
Yeah. Well, I guess one issue I take with, not an issue I take with the question, but my hesitancy in answering that question is that, in my mind, that kind of conflates sustainable and organic together, which I consciously go out of my way to disentangle the two. Subsidies already exist, as you said, for conventional production, and I think the heavy lifting of sustainability. I mean, you can talk about sustainable from a single farm perspective of how do we make resources reusable so that one single farm can sustain itself without outside inputs or with as minimal outside inputs as possible. But on a more macro level, the bigger question is how do you sustain the human population? And organic production, I don't think is going to do that. I just don't think it can. Maybe I'm wrong. In a great world, I'd be happy to be proved incorrect, but I don't think that it's going to be able to keep up with the population. So, do I see subsidies being handed out? I mean, they already are for conventional agricultural production, and that comes with. There's a pejorative connotation associated with subsidies, but at the end of the day, we're buying a stable food market. It's not a give out. It's not a hand away. We're buying stable food. So I don't know if that answers your question. Yeah.
So just to follow up on that, do you see, or do you know if this is part of the advocacy, is the issue of sustainability for kind of legal purposes, how does that come into sort of federal policy towards farming? I mean, is this something that maybe, building off that prior question, that this will become something that is going to shake up the idea of how the federal government subsidizes various parts of agriculture?
Sure. Well, you already see a little bit of that going on currently. The legal definition of sustainability is used in the acronym is SARE. I believe it's Sustainable Agriculture Research and Education, and that's a federal organization that sends field agents out to educate farmers about conservation practices and sustainability, and additionally provides grants to farmers and operations who are trying to develop sustainable ideas and implement those practices into their farm. So you already see the legal definition being used, carrying some weight. So I guess the question is, could that be even more robustly expanded in the future? Yeah, I think so. And I think that you see, as infrastructure continues to build, if the government decides that they want to expand out beyond, SARE into further organizations or agencies, then yeah, that legal definition could do even more heavy lifting.
We are at the time, so people want their 15 minutes of coffee. Thank you so much. These were all fantastic.